According to the Data Institute at the University of San Francisco, historically, epidemics are a time of fear, confusion, and helplessness because men are faced with danger and uncertainty. And at least according to human psychology, man has only two choices in the face of crisis: fight or flight. Some men run and some men stay, some men fight and some men flee. But fortune, at least in the Ranger Regiment, always favors the bold. Hello, my name is Major Mike Webb, retired Army Ranger and formerly the Operations Officer for all U.S. Army Strategic Counterintelligence in the continental United States. And when an invisible enemy that emerged in China had traveled to the United States, when most everyone began to run away, closing businesses, churches, and schools, placing social distance between themselves and others, and doing anything that they could to avoid confronting a novel coronavirus, I decided to do things just a little bit different. I decided to do it the Ranger way and became a person determined to catch COVID-19 in court. And the following are true crime stories that arose in my determination to catch COVID-19. There is a very popular saying, familiar to most, that you can't fight City Hall. And in the Commonwealth of Virginia, as any plaintiff who has ever attempted to bring suit against a government entity or regulatory agency or board knows, the doctrine of sovereign immunity is alive and well in the Commonwealth of Virginia, which essentially is what attorneys and legal practitioners would describe as a doctrine of deference. And perhaps for the non-litigators, that is a concept that requires a little more development and further explanation. And one of the reasons that it is often said that only a fool represents himself in court is because unless you have been to law school and had at least a little experience in law school, these legal terms of art may not mean what you think they mean, even if it may sound good when you're trying to debate legal points with your friends. Generally, under this doctrine of deference, the power of the courts could be used, may be used, can be used to modify or reverse an order or regulation when it is satisfied that it is contrary to law, which should be self-explanatory. And in a rule of law, it should be axiomatic that no power can be exerted unless it can be found in some express delegation of power, or in some power to be properly implied therefrom. If it is not in the contract, you can't do it. And that pretty much applies to when a matter turns on the interpretation of law, which in a court of competent jurisdiction is the sole decision of the judge, because dating back to the decision in Marbury v. Madison, it is the emphatic duty and province of the judiciary to say what the law is. And so when it is said that you can't fight City Hall, what this essentially means with regard to the law in a courtroom is that a facial challenge, attempting to repeal a legislative enactment, is the most difficult challenge to mount successfully, since the challenger must establish that no set of circumstances exist under which the act would be valid. It is a categorical argument for those who are familiar with logic. And that works like the burden of proof in a criminal case, where if there is even any reasonable doubt that a defendant is guilty, he or she will be acquitted and found not guilty. Not necessarily innocent, but not guilty of the charged offense. If there is only one limited instance when the regulation or statute might be valid, a plaintiff similarly will not prevail on the merits in court against the government or city hall. And you can imagine how much more that may apply when a litigant attempts to sue the government during a once-in-a-lifetime pandemic. You can only imagine the pressure to side with the government during a pandemic in which the former Attorney General for Virginia, Mark Herring, had even argued to the court that dealing with an emergency situation requires an immediacy of action that is not possible for judges. But also the power of the court may be used to modify or reverse an order or regulation when it is satisfied that a decision is unreasonable, arbitrary, and capricious, and thereby constitutes an abuse of discretion, which may turn on an interpretation of the evidence or facts of record, for which in a jury trial the jury is designated as the trier of facts, which are generally presented to a court by witnesses rendering oral or written testimony, and in a clear, bright-line rule statement of the controlling rule, findings of facts shall not be set aside unless clearly erroneous, and due regard shall be given to the opportunity of the trial court to judge the credibility of the witness. Further, under the deference doctrine, the government would essentially have to be clearly erroneous in its interpretation of the facts before the court. And a finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. And you can only imagine the pressure to side with the government during a once-in-a-lifetime pandemic in which former Attorney General for Virginia, Mark Herring, had even argued to one court that attempting to precisely define under what specific conditions each of the authorized restrictions might be imposed would destroy the broad discretion necessary for the executive to deal with an emergency situation. And with that foundation in the legal terrain, we can now apply an acetate overlay of the facts that brought us in a confrontation with City Hall in the city of Alexandria during a once-in-a-lifetime pandemic crisis, times historically associated with fear, confusion, and despair. And as in the previous video, perhaps this context will present a clearer picture as to why, in this case, and no other of record in the Commonwealth of Virginia, or in any other case in America, this government defendant elected a dubious right to remain silent and decided, rather than surrendering to the personal jurisdiction of the court, to run. The landmark case often referred to during the pandemic, at least in the news commentary, was the case of Jacobson v. Massachusetts, a precedent that Robert F. Kennedy Jr. actually wanted to have repealed, a case revolving around a vaccine mandate in the city of Cambridge in 1905, and in which the Supreme Court had stated a rule that the only competent evidence that could be presented to the court to prove these propositions was the testimony of experts giving their opinions. And so one of the first things that a court is going to ask you when you go to court is, are you a doctor? Not just are you a lawyer. Do you have a doctor's note or opinion? And with the declaration of a pandemic by the World Health Organization, what better authority to have to present in court might there be than their extensive report, spanning some 40 pages, on the outbreak that had erupted in China in December 2019, even though one of its authors had noted very early that it didn't appear that anyone had ever read his 40-page document. A robust examination conducted by 1,800 teams of at least 5 epidemiologists, examining a total of 55,924 laboratory-confirmed cases, which was 19 times more cases than had yet been reported in the entire nation by mid-March 2020, and far much more than were reported in the entire Commonwealth of Virginia on March 15th, 2020, when Governor Ralph Northam locked down the entire state of over 8 million people with just 45 cases of COVID-19 and 1 fatality. And under the rule stated in what is often described as the DACA case, decided that summer, DHS, the Board of Regents, or the University of California, it is a foundational principle of administrative law that judicial review of agency action is limited to the grounds that the agency invoked when it took the action, what was known at the time. And contrary to claims of evolving science in the courts, an entry in fact that is concrete and particularized and not conjectural or hypothetical is what is required. And accordingly, courts have traditionally eschewed speculative damages. Some have advocated for embracing the 1978 UNESCO precautionary principle. But as noted in Sancho v. Department of Energy, that treaty has never been incorporated into domestic law by international treaty or otherwise. If it is not in the contract, you can't do it. And no power can be exerted unless it be found in some express delegation of power or in some power to be properly implied therefrom. And yet, for still unknown reasons, when an online complaint based upon that report from the WHO had been filed with the city of Alexandria, rather than respond to the online inquiry, on March 21st, 2020, they decided immediately to acknowledge acceptance of the comment and then immediately closed up the case without further action, giving rise to the very first and longest surviving litigation against the lockdowns in the Commonwealth of Virginia. And under the rules stated in U.S. v. Lutheran, participation in the formation of a conspiracy is not essential to culpability if after it was formed the defendant aided or abetted it with an understanding of its purpose. While initially choosing to evade the summons, Mayor Justin Wilson and the City of Alexandria finally entered an appearance to present only two principal arguments: a lack of justiciable issue, or a failure to state a legal cause of action, as well as the wholly ludicrous claim of a lack of standing based upon the premise that the plaintiff was a resident of the County of Arlington and that his membership in a church in Alexandria, which had been affected by the lockdown orders, failed to establish legal standing to bring the case, despite the direct and personal injury to the plaintiff's rights guaranteed under the Free Exercise Clause. Yet some courts have held that there must, in addition to such knowledge or approval, be voluntary, willing, knowing, and intentional cooperation or agreement to cooperate before there can be any conspiracy. And furthermore, in order to show withdrawal, the defendant must show that he has committed affirmative acts inconsistent with the object of the conspiracy that are communicated in a manner reasonably calculated to reach other conspirators. Mere cessation of activity in furtherance of the conspiracy is not sufficient to show withdrawal. But most problematic for the city was the failure of the city sheriff, Dana Lawhorn, to comply with the duly executed and filed precipice that had been filed at the commencement of the action, to direct him to serve process upon the governor and other Commonwealth agencies, which even after a year, as the Attorney General himself conceded in court, had never been done. During the trial of the Nazi war criminal Adolf Eichmann, the court had noted that even the laws of the Third Reich had acknowledged that even the jurists of the Third Reich did not dare to put on paper the obedience to orders is above all, and that the distinguishing mark of a manifestly unlawful order should fly like a black flag above the given order as a warning reading prohibited. And yet, Mayor Wilson and Sheriff Lawhorn would later attempt to evade service of a summons again when a case was brought in June 2021 to attempt to enjoin the city from the annual observation of Pride Month, essentially encouraging gay men and members of the LGBT community to engage in reckless disregard for any precautions in revelry during a once-in-a-lifetime pandemic. And rather than concurring that that same abundance of caution that had been applied against places of worship, schools, and businesses should be extended, in this instance, Mayor Wilson and the City of Alexandria, with the assistance of the sheriff again, decided to run, just as had been done in a recent case brought this year regarding the absence of any authorization under the city charter to even issue the controversial proclamation for Pride Month, particularly within the religious faith community. However, under 18 U.S.C. Section 1512, it is actually a felony offense, punishable by fine and or up to 20 years in prison for whoever corruptly persuades another person or attempts to do so or engages in misleading conduct toward another person with the intent to evade a summons or to be absent from an official proceeding to which such person has been summoned by legal process. Yet far more distressingly, after former Virginia Governor Ralph Northam had, in December 2020, conceded that he could not legally limit in-person worship ceremonies, noting that a recent Supreme Court decision against the state of New York prevented him from doing that. And yet, nonetheless, blaming churches at the same time for contributing to the spread of the virus, noting that some houses of worship were not social distancing or wearing masks, informing faith leaders and their adherents that God is wherever you are, and you don't have to sit in a church pew for God to hear your prayers, explaining that this year we need to think about what is truly the most important thing. The case was reopened against Mayor Wilson to acknowledge the concession of the governor, but rather than conceding and acknowledging the same, Mayor Wilson attempted again to distance himself from the actions of the former governor, arguing that neither he nor the city were the principal authorities responsible for the restrictions on the churches, and essentially making the argument that he had only been following orders. Yet it is well established that the acts of a subordinate done in compliance with an unlawful order given him by his superior are excused and impose no criminal liability unless the superior's order is one in which a man of ordinary sense and understanding would, under the circumstance, know to be unlawful, or if the order in question is actually known to the accused to be unlawful. Under the laws of the Commonwealth of Virginia, as expressed by the state Supreme Court in 1884, in the matter Hill v. Woodard, the court stated, reviewing similar facts where a defendant had evaded the courts, that it was not only competent for her to speak in time and be made a party if she had not been, but it was her duty. And in the trial of Adolf Eichmann, that court had found most dispositive the fact that undoubtedly he knew the tale of the administration of the tonics to which he had put his signature. This briefing is unclassified. Stay tuned for the next episode of Catching COVID-19 True Crime Stories. My name is Major Mike Webb, and by God, I am running for state delegate in Virginia's 49th district. No man is above the law. Honest.
This advertisement was authorized by Mike Webb.